our next edition of CII Startup Buzz. Every Thursday, 5 p.m., we get a new topic. And today is probably one of the most important topic. We couldn't have a better speaker. Rohini is here with us, and Robin is going to moderate. Both are rock stars in their own field. And I'm sure next 45, 50 minutes, you will learn a lot more. Thank you again for joining. Stay tuned at CII. We are endeavoring to ensure that every Thursday you get some topic which is relevant for startup ecosystem, which makes you wiser and hopefully gets you on the road to become a unicorn. So with that, I'll hand it over to Robin, who will moderate the session. Thank you.
Good evening, everyone. Thank you for joining this wonderful session. Hopefully, it will be wonderful. Rohini, as was explained, is a rock star, of course. She's a lawyer, and she has a long background of whatever she has done, and very impressive, apart from the fact that she advises large companies. But most importantly, she's a professional dancer. She is an acclaimed dancer, professional, I'm not too sure, but she's an acclaimed dancer. So to have the two ends meet, the dancing and being a fantastic and fine corporate lawyer, I wonder how Rohini does it, but that's what, ladies and gentlemen, Rohini is in front of you. Having said that, the topic of our discussion today is shareholders agreement. It sounds very legalistic. It sounds esoteric. And therefore, it was thought fit that we demystify, unravel this mysterious stuff called shareholders agreement. And without taking much of your time, I would now shoot the first question to Rohini. Rohini, just to start, if you could explain in short, what is shareholders agreement and how it is relevant for a startup entrepreneur. What is shareholders agreement and how it is relevant or important to startup entrepreneurs? Rohini, over to you.
Thank you, Robin, for that kind introduction. And Ninad, good evening. Thank you for having both of us on board. And good evening, everyone. Now to the question that Robin posed, how important is shareholders agreement? I think every time that a founder tries to raise capital for its business, I think any promoter trying to raise capital for its venture has to execute a share subscription and a shareholders agreement with the investor. Shareholders agreement primarily is a document that draws up the framework which sets out the rights, privileges of an investor who is coming on board, and also the obligations of the company as well as the promoter towards the company as well as the investors. Now, the rights of an investor depends on various factors. One, of course, is the size of the company at which the capital is being raised. Two is the check size, which is being taken from the investor. Apart from the capital, what is the other things, what is the value add that the investor is bringing on the table for the company? I think that's basis which the entire shareholders agreement is drawn up. Now, as far as the obligations of a promoter is concerned, there are a couple of things which are pretty standard, and you will see it across all shareholders agreement. One, of course, is the non-compete, non-solicit, the idea being that the promoter devotes 100% of their time towards the operations of the business. And the fact that while they are a part of the company and probably during a cooling off period after they cease to be part of the company, they cannot do XYZ things which are competing with the business. Second is that because the investors have invested, keeping in mind the promoters who are face of the company, it is a fair expectation that the promoter should not really dilute their stake and liquidate their stake and make money out of it at a subsequent stage while the investor is still invested. So therefore, you will see a lot of lock-in provisions in the document built in. Now, then the question is, why is it called a shareholders agreement? Why not call it an investor agreement? The reason being, between the company, promoter, and investor, you also have some existing shareholders. Typically, I mean, I always tell companies that you should always raise money also from your friends and family. These are friends and family shareholders who bring in money, but their expectation is not that they want some great rights as an investor. So these are existing investors, advisors, they're all shareholders. So the idea is that each and every person who's on the cap table of the company are signing up on that one document, which is called the shareholders agreement. I can't hear you. You're on mute.
I want to ask you, okay, what I've understood from you, Rohini, is that a startup, let's start with a startup. Startup can get money from two sources. They can get money as an equity, which is the owner's fund, who technically are shareholders. A startup can also get money from a bank or from a lender, from a financial institution. So they are all lenders, which means I have borrowed. Now, you have explained a shareholder agreement is where a person or a group of people are contributing towards the equity capital of the company, the shareholders who ultimately becomes the shareholders. You have distinguished here that the existing shareholders, mother, father, parents, sister, brother, they could also be a shareholder, but they don't need an agreement per se. But the new shareholders who are coming in needs a piece of paper, and that piece of paper is called typically a shareholders agreement.
Yes.
And you said in that in this shareholders agreement, the piece of paper, there are some obligations which are being taken over by the so-called startup company who is taking in the money.
Yes.
Now, if you could, I do know that you did mention some obligations, and the listeners today are typically either startup entrepreneurs or working for startups. What is the most important stuff that startup entrepreneurs should look at when they're seeking money from the shareholders, which means by the time they are trying to sign this piece of paper called shareholders agreement, what is that most significant stuff they should be aware of? There could be one or two.
Okay. I think before you come to the shareholders agreement, in my experience, what the common mistake, if I can say, a founder does is signing off on a term sheet without really realizing the implication of what they're signing off on. And what essentially happens is the term sheet that you sign off gets replicated or probably becomes more elaborative form in the SHA. Then what you've signed off on the term sheet to renegotiate and reopen the agreed points becomes very difficult in a shareholders agreement. So essentially, if one has to take a look at the shareholders agreement, I think term sheet also needs to be looked at. That is one part. Two is, I always tell founders, because I've been on both sides of the table, I've represented quite a few investors and I can still continue to. And I also work with a lot of founders on various deals. What I tell them is control and management of the company at all times has to be with the founders. That is something which is of paramount, like it's important. I can't even emphasize how important it is. The reason being, you as a promoter have a vision for the company. That is what led you to start the business and incorporate that company. You know the vision. To an extent, you can put it in a piece of paper called a business plan. But it is you who has to drive it. Now, when you are the one who has to drive that business, any kind of hindrance in the day-to-day operations by any person can make it very difficult for you as a founder to run your operations. So while an investor could seek veto rights, reserve matter rights, basically to say that there are A to Z items on which you have to go to the investor for a consent before you proceed with it. Let that be there. Should you think that the investor is worth it, give that. But those matters should certainly not involve those matters which are of day-to-day operations. So in that sense, you have a control over the operations, not only by virtue of you having a controlling stake. Essentially, if you see a startup founder, up until they reach a Series B stage, they tend to have a controlling stake. May not be Series B, Series A. They have a controlling stake. They have 51% and above as a stake, equity stake. But if you look at the shareholders agreement, you will see that they do not have control or management rights, which makes it very difficult for the founders to operate. That is one. Two, your non-compete provisions have to be watertight. Today, you are in this business, you don't know what you're going to be doing tomorrow. I have had multiple cases where promoters have come to me after they or when they intend to leave the company and they want to do some kind of business which is not probably directly competing, but there is some nexus drawn. So the non-compete restrictive covenants have to be absolutely watertight. It is unfortunately being seen as a boilerplate clause. In legal parlance, a boilerplate clause is like any other clause, like a governing law or a jurisdiction, which you always see. There are standard clause. It is not standard. It is not standard. It differs from business to business, essentially. So that's something which is very important.
Very well said, Rohini. I know I'm interrupting your thought process.
No
You have
problem.
so much to say. I just wanted to summarize for my listeners that you have actually told or stated four stuffs. One is there should be a term sheet, which I guess is a piece of paper that write down your thoughts. What is it that you want to give up and what is it that you want to take? It's not a legal document, but it's a thought document. It's called term sheet. You may like to explain what is a term sheet. But before that, three more stuffs which you said. You will please explain what's a term sheet because that's the word you used. But for the startup entrepreneurs, you gave a very good hint or advice that please look at the control and management. Do you want to give up the control? Do you want to manage the company, or for the sake of money, do you want to give up the control? So control and management is very important. That is what you said. You've also said that most of the time, up to Series A, Series B funding, the promoter still seems to be having 51%. Thereafter, they start diluting because you have to give up shares to get money. And therefore, the control and management is very important to be thought through before. And the third, very important, is non-compete. What happens after 5 years, 10 years, you want to leave the company, want to do something else, because you already by that time maybe holding 10, 15% of the company. So you should think of upfront what the non-compete clause is. Could you kindly explain what you had in mind by the term sheet?
Yeah, term sheet is a legal document. It is a piece of paper, like you say. I like the way you call each and every document a piece of paper. But so it is basically a non-binding document wherein the investor, the company, and the promoter agree that what is going to be the tentative check size, what's going to be the tentative percentage holding of the investor post-closing, and towards the subscription amount that they're going to be remitting, what is the instrument that they're going to be getting. So like you rightly said some time back, it could be an equity, it could be a debt instrument, like a compulsorily convertible debentures or a convertible note, depending on what the instrument that the principals have agreed upon. And also the investor rights that they're expecting from the company and the promoter, and what is the expectation from the promoters, in the sense they can't transfer their shares, and if they intend to transfer, they're supposed to take consents. So all those clauses tend to be briefly mentioned in a term sheet. And one other clause which you'll always see in a term sheet is that a no shop clause, that you can't while you are negotiating this deal with a particular investor with whom you're signing the term sheet, you can't be shopping around, looking around for other investors. And if you are, then you're supposed to, let the investor know and take their consent, so that you're not using this term sheet to really get a better term somewhere else. And of course, it sets out the pre-money valuation of the round and so on and so forth. So it's a non-binding document in that sense, but the idea is that when you sign off on that, then those terms you ideally should not renegotiate at the time of definitive documents. Definitive being the share subscription and the shareholders agreement. That is how you will see it.
So a term sheet signed by the two person, the giver and the taker.
Yeah.
And if the term sheet is not signed, it's a piece of paper. But once it is signed by the two people, then it's not a piece of paper, it's a document. And you say the shareholders agreement normally would reflect the terms which is agreed in the term sheet. Now, assuming there is a term sheet signed and there is a shareholders agreement signed, and there is a problem later on, which one will prevail? The shareholders agreement or the term sheet?
No. So by virtue of your shareholders agreement, there is always a clause in the shareholders agreement which will say that upon execution of the shareholders agreement, all the other letter, document, whatever has been executed, it gets superseded by the SHA. So the SHA prevails.
Wonderful, wonderful. Now, a startup wants to raise funds. And the fund could be equity, fund could be debt, but assuming a startup normally would get equity because debt to uska paas hoga nahi most of the time, because they may not have maybe things to give as mortgage or hypothecation. Having said that, assuming it is equity, how should a startup entrepreneur be investment ready? That means what all things the startup entrepreneurs needs to do before raising this capital, which is called equity. And at what stage should the startup entrepreneur come to a legal advisor like you so that the transaction could be completed?
Right. Just to take a step back on what you said, debt is also a preferred route for startups who are into basically manufacturing. So if they have plants, they have warehouses, you will see that because they're capital intensive, equity will not suffice. They will have to perhaps take debt, may not be from banks, but probably other non-banking financial institutions like the NBFCs and all of that. You will see that. And therefore, that at that point in time, the promoter tends to put the plant documents, etc., as collaterals, their shares as collaterals, their personal guarantees, all of that you will see. But that being said, the way I would put it for a startup and a founder to be investor ready would be that and I keep telling my founders this, the time that you've incorporated a company, from that day onwards, there has to be a virtual data room created, because today we are all going go green, so nobody takes printouts. But all the documents that you sign off on, each and every document that you actually submit to a regulator, be it the registrar of companies, be it the GST authorities, be it the tax department, could be any authority. A copy of that should be in the virtual data room. Create folders, subfolders, and put it in there. Year and year wise, you should actually create those folders, dump the documents there, so that when you go in for raising capital and the investor wants to do a diligence, the documents are very well available in the virtual data room. And it is just about probably shuffling it a little bit based on the diligence checklist that the investor would share. Because each and every investor council will have a different checklist that they would have. And they would expect the startup to actually align the documents based on the checklist. More often than not, what I have seen and what we've all seen as legal counsels are that the founders are unable to post when you have a checklist come from an investor for diligence. And there is a lot of time spent from the time that you've received the diligence checklist to having actually made available those documents. And then you start backdating the documents, all of that happens, which is not a very good practice. So that is one piece which is very important. You have to ensure, and you'll also see that the company secretary, the CAs are not available. And because you are chasing them at that point in time, and at that time, there could be an annual filing which they'll be busy with for their clients, they're not available. So you're wasting a lot of time. That's the time you can crunch down. That is one. Two, I think it's very important to figure out what's your business plan, even before you actually reach out to your investor. What is it that you're raising capital for? And you'll also see that, like you rightly said, you tend to raise loan from your mother, father, basically family, friends. What do you intend to do of that loan? Do you intend to repay? Do you intend to convert into equity? What is it? Because be rest assured that once an investor comes in, he will not let you use his capital to repay the loans. That's not what the money came in for. So that's one important piece that founders tend to neglect or ignore, which is something which one has to be mindful of. And one important thing is ESOP. So if you have a lot of employees, your employee strength is good, you want to probably motivate them by giving them ESOPs, build that in, provide for it, so that you're very clear that this is something which you've committed and the investor has to agree to it. There are no two ways to it.
Good thing. I love this idea of thinking of the ESOP, which means when you're raising money now, really think of the future. One of the do's which you said, whenever anyone wants to raise new money, please keep your data room ready, which is nothing else but a place where dump all the data as much as you have, because push comes to shove, when it really means time is essence, you will find your CA missing or the lawyer missing, your advisor missing, because they may be having other things to do. Great idea. You also mentioned that a startup entrepreneur not only gets money from equity, but they also take money from debt. But when they're taking money from debt, obviously they are not signing a shareholders agreement. They're signing then a debt instrument agreement.
Yes.
Could you kindly distinguish the basic differences between a debt instrument, which the startup entrepreneur would sign, and a shareholders agreement, which you have been talking about today? The critical, crucial differences.
In terms of differences between a debt instrument and an equity, right? Now, debt can also be a convertible debt, which is technically convertible into equity. That again comes in the equity instrument.
For the time being, assuming it is non-convertible.
So debt versus equity. In debt, you're not diluting your stake. There's no dilution because you're not giving out shares of the company. So there is no dilution that happens. Your shareholding pattern, the shareholding structure remains intact. In case of an equity, you are getting diluted. In case of debt, for an investor, there is a surety that you're going to get your money back. So it's not that much of a risk. So you have to be paying interest on a periodical basis that you've committed, because there's a coupon rate attached to your debt that you raise. So you have to be making periodical payments. If you don't, then there are consequences. In case of an equity instrument, all you have to do is you're committing that on a best effort basis, you will try and give the investor an exit after X number of years, which is 5 or 7 or whatever that you've principally agreed. Technically, it should be 7 as much as possible. But yes, in case of debt, while you say that you're going to be repaying the entire amount within 3 years, but the idea is that you start paying the interest component periodically, which is monthly or quarterly, whatever that you've agreed upon. And if you default on that, then there are significant consequences. The third thing is your assets, because it's a secured debt, you are giving collateral. So that is at the risk of being liquidated to realize the money in case you default. So that also sort of puts your assets at risk. In case of an equity, all you're doing is you're giving an equity stake in the company, which of course, if the company goes down the hill, then the equity stake is literally a piece of paper, honestly.
Excellent.
Right?
So what you said, a debt instrument would have an interest clause, how much interest you have to pay. It will also have a principal repayment period, principal repayment liability mentioned.
Yes.
There could be some holiday period, 6 months, 1 year. After that, the principal will have to be paid. So essentially, a debt instrument will have the liability clauses mentioned, how much interest and principal you have to pay. And shareholders agreement, an equity shareholders agreement would not have any liability per se. If the company does well, hopefully dividends will be declared. If the company doesn't do well, then the money will get lost because the company could get liquidated. Excellent. In a startup environment, when an entrepreneur starts, what should be the right structure? Should it be an LLP you would prefer, or should the uh, entrepreneur make or set up a private limited company as an investor or as a lawyer? Which is the preferred route, an LLP, limited liability partnership setup, or a private limited company setup? What's the preferred route?
If the intent is for the company to raise capital from private equity venture capital investors, then the only structure is private limited company. There's no other way out. Because if you look at a LLP, the investors will not invest. They'll expect you to convert the LLP into a private limited company. While, of course, the reason why founders do go for the LLP is simply because it is less compliance heavy as against a private limited company. There are less filings to be done. There are no registers to be maintained, and so on and so forth. But a PVC folk will not look at the LLP. They'll expect you to either convert or set up a new company, which is again going to be not very cost efficient for the company. So the ideal structure is basically a company. It could be a public company or a private limited company. It doesn't matter, but generally a private limited company is what you will see. Because again, in a public company, you will find that there are no enough exemptions given, while a private limited company has a lot of exemptions under the Companies Act.
So you would prefer a private limited company or a limited company setup instead of an limited liability partnership setup, which is LLP setup.
Right.
Excellent. There are lots of questions flowing in, Rohini, just for information. But before that, I just want to ask you a quick question before start taking the questions. As regards of funding routes are concerned, there are several rounds of funding. There's a lot of nomenclatures mentioned: angel funding, seed money funding, pre-series A funding, series A funding, series B funding. So complicated, Rohini. Can you kindly unravel this whole mystery of such wonderful words called angels and gods?
Yes. So angel funding is usually done by those individual investors who come in very early on, and their check size technically does not go beyond maybe 1 crore. Their check size will not go beyond that. It'll be in fact lower than that. In fact, the entire round of an angel funding round will not go beyond 1.5, 2 crore. That's how where it is. So check size will primarily be 25 lakh, 50 lakh, 15 lakhs, that kind of a thing. This is the round where you'll actually have your friends and family investing. And I always tell my founders that you must raise capital from friends and family, simply because tomorrow when you go to an institutional investor, they can see that there are your own people who backed you early on in your venture. And that does add value to the company in terms of the initial capital, the initial thrust that you need to start your operations. That really adds to the company's business in that sense. Then you have is a pre-seed round, which typically is between it's 5 to 10 crore. That's where you will see it. Up to 20 is what you see Series A, 20, 30. And so on and so forth. You'll have a Series B, Series D, C, D, depending on how many investors are you taking on board. For example, I have been part of companies where, we've been with them from their seed round to a Series D round, and then they got flipped to the US. There was an externalization that took place. So it really depends. Unfortunately or fortunately for us, the regulations do not define what a Series A or a Series B is. It really depends upon how the markets are. And it's technically the markets that drive how the round size looks like at a Series A or a Series B or a pre-seed stage. But what I said is primarily how it looks like, by and
So
large.
can I say that these words, angels, seed, pre-series, series A, these
Yes.
are various rounds of investment. First round, you take from families, friends, which is called angel investors. They're angels. They're almost angels. They're from heaven, gave money. Are kuch chalu karo, 10, 15 lakh de diya. Then
Yes.
comes seed, maybe they get 2-3 crores each, people would have given. Then you keep on adding more and more investor, more and more money.
Yes.
Now, as regards angel investment is concerned, angel and seed, is there a concept of having a shareholders agreement even in that stage, or it's not there prevalent?
No. So look, so again, let me break this down. Under law, so a private limited company is run and operated and governed by the Companies Act 2013, right? Earlier it was Companies Act 1956. 2013 Act is what we follow now. Now, under that regulation, the concept of shareholders agreement doesn't exist. So under law, you're not required to actually execute a shareholders agreement. The reason why we do that is in order to iron out the understanding between the inter se shareholding, inter se shareholders' rights, obligations, and their understanding is put down in writing, is why you do a shareholders agreement. Now, like I said some time back, when you have your friends and family, or even for that matter, angels coming in, their expectation from the company is not that they want to control the company, because these are individuals. So you can certainly avoid signing a shareholders agreement in that place. You can actually execute an I-safe. So the way you have in the US, you have a Y Combinator, which rolled out a safe note, which is like literally a 5-pager document by which you could easily raise capital. The same way with the angels in India, in India, these startups can actually execute an I-safe. It's basically the Indianized version of safe note that 100x VC came up with years back. And that is something which you can use for your angel investors, simply because the expectation from them is not that much. So there are no critical rights, obligations we're talking about. So it could be a simple 10-page document that you execute, whereby you simply set out what all information will the company share periodically with them, what's going to be the pre-money valuation, what's the investment amount, and yeah, and the basic founder obligations towards the company. That's all.
So you are saying the shareholders agreement is actually not mentioned in the Companies Act, neither in 1956 Companies Act or 2013 Companies Act. Now there is a dispute. When there is a dispute, under which law should the dispute be? Under Contract Act or under Companies Act, or for that matter, Negotiable Instrument Act, or for the matter, any other act? Where can or which law will guide a dispute?
You missed out arbitration also, right? So, okay.
Wonderful. I agree. Yes.
So, if there's a shareholders agreement, okay, in place, what essentially happens is that you'll always find an arbitration clause, a dispute resolution clause. So the first thing, in case of a dispute, and if the arbitration clause, there are certain disputes which you can't really go under arbitration. For example, a criminal proceeding you can't initiate against under arbitration. So the first thing that you do is under the Arbitration Act that you go. Okay, you invoke arbitration and let the arbitrator sort of mediate and try and arbitrate the dispute in question. Now, yes, you're right. When there's a dispute that arises, the tribunal that you go to is the NCLT, the National Company Law.
NCLT is only case of a large company more than a particular. Gross size?
No, not necessarily. In fact, the Companies Act has set out the tribunal, has constituted a tribunal only for Companies Act matters. So you have to go to the tribunal for that matter. However, depending on how the proceedings are and what kind of dispute we're looking at, there will be a scenario where you'll have to go to the High Court as well to be able to get some injunction. So to answer your question in brief, your Contract Act also gets triggered, so does the Companies Act, so does the Arbitration Act, depending on the nature of dispute.
Fair point. As I said, Rohini, you have been so articulate and people are hooked on and loving whatever you're saying. But the last question before I take on the questions, can you explain to me this whole exit provision, exit clause?
Yeah.
Because whoever is investing, many of them may want to go out in a few years' time, or a few months' time. Quickly and in short, if you could explain what is this exit provision and what the startup entrepreneur should take care of to draft exit clause. In short, if you could, please.
Yes. So as an investor, when I am putting in capital into a company, my intention or my expectation in the company is that after some X number of years, I should get my capital along with some return. Now, there are various modes and means by which a company can give an investor an exit. More generally, that the mode of exit that you see is a third party sale, which is in the subsequent rounds that the company does, the company will ensure that the incoming investor partially buys out the existing investor, and the other part of the investment is put into the company. The reason why that happens is also that by the time you reach a Series B or a Series C stage, you want to clear up the cap table. At the angel round, pre-seed round, you've taken money from a lot of individuals, lot of smaller investors. At a Series B stage, you can't be having 30, 40 investors. By the way, under Companies Act, you can have shareholders up to 200. You can't have it beyond that. So if you reached a 30, 40 number, it's quite...
That is for a private limited company, I guess you are saying.
Private limited company, 200. Now, if you have 20, 30 investors, idea is that at that stage, you'll have to go to all 20, 30 people to sign off on the shareholders agreement, which will be very, very difficult. So what happens is from a Series A stage, the company and promoter tend to ensure that the smaller investors who were invested from day one are bought out by the bigger institutional investors coming in. So for example, if an institutional investor is committed about 20 crore, part of it probably, say, 10 is probably parked for being bought out to buy out the existing investor shares, and the other 10 is invested into the company. That's one way that you'll always. Other than that, in case at a later stage of the company finds a brilliant offer from a bigger giant company, which is a competing company, and they want to buy out the company, which is a great opportunity. And at that time of a buyout, the investors all get an exit because the idea is a strategic buyer will take out the entire 100% or at least majority stake in the company. That's a strategic sale concept. Third is a buyback option, which is provided under Companies Act, which is extremely difficult because the Companies Act says you can't buy back the company. In this case, the company actually buys out the shares of the existing investor, which is very difficult because in a particular year, the company cannot buy buyout beyond 25%. There's a threshold there under Companies Act. And there are various restrictions around it. So practically, buyback is slightly challenging. The fourth is not a very good scenario, but if at all the company fails to give the investors an exit, then there's something called as a drag sale, whereby in case the company is not doing well or the promoters have done some acts which is not in the interest of the company and the company has significantly suffered. So the investors take charge of the company and they sell it off. Idea being that whatever can be realized, let's realize it and let's just leave the company. So that's a drag sale where they drag.
There's a drag along and a tag along. Can you explain these two words, please?
Sure. So in a tag along, what happens is in case a founder is selling their shares, of course, with the consent of the investor, proportionately, the investor has a right, but not the obligation to tag along with the founder in that sale. So for example, if I as a founder, I'm selling 5% of my stake to a third party, you as an investor can proportionately, if you're the only investor I have on my cap table, proportionately, you can also sell your stake to third party. I have to facilitate that to happen. If the third party says he's not ready to buy your shares, then I also cannot sell. So that's a right that you have. A drag sale is where you as an investor has the right to drag me into a sale. You can sell off the entire company, including my stake.
So are these drag along and tag along rights or obligations mentioned clearly in a SHA, in a shareholders agreement?
Yes, you'll always find them.
Wonderful, wonderful. I think you are already started answering questions which are getting raised because our listeners here are very educated. What are the legal implications? What are the legal implications for founders when an IPO is taking place or when an acquisition M&A is taking place?
What are, sorry, say it again?
M&A, an acquisition is taking place.
Yeah.
Now, I'm a founder, I'm a startup founder, and now we get into an IPO.
Yeah.
What should be the shareholders agreement looking like? Because now you're going to an IPO. I presume the shareholders agreement takes a shape and form of a prospectus and so on and so forth. Could you please explain how that stuff works, how that shareholders agreement works from a private limited company or an LLP now getting into an IPO, a public company situation? How does that work?
Yeah. So essentially, when a company is going IPO, in fact, for the last couple of years, if you see, there are a lot of investment funds which have come up, which are predominantly investing in pre-IPO companies. The reason being that you see a lot of traction, there, a lot of action happening at the pre-IPO stage. So what happens in that stage generally is that one, of course, the private limited company gets converted into public limited company, one. Two is that the shareholders agreement that you see gets trimmed down significantly, because then the share transfer restrictions, all the other rights they trim down significantly. You can't have a PVC transaction document being replicated at that stage. That is one. And of course, there are SEBI guidelines laid down, the ICDR regulations, the DRHP has to be drafted accordingly. You require a merchant banker. You need to do an extensive diligence on the company, because every regulatory red flag that you see has to be highlighted in the DRHP, the prospectus document that you see. And also what happens is that the existing investors who've been there with the company early on, they all get bought out by the anchor investors who invest in the pre-IPO stage. You'll always see that. So there's a complete shift in the cap table that you will see often, not always, often.
You have used the word cap table. Could you explain to what is a cap table?
A cap table is nothing but the table which sets out the shareholding of each and every shareholder of the company, the number of shares that they hold, be it equity, be it a compulsorily convertible preference shares, and their percentage holding. So the total paid up issued share capital of the company is what gets reflected in the cap structure, cap table, shareholding pattern. It's all synonyms.
So when a private company or a startup company gets into an IPO, initial public offer, you are saying that the DRHP or the draft red heading prospectus, that forms the so-called new shareholders agreement with much more disclosure requirements. And then you also get into because it's a public company, you get into, I presume, SEBI regulations, public company regulations, and so on and so forth. So the company becomes more regulated because you are taking money from the public.
No.
But saying no, go ahead.
No. Prospectus DRHP is nothing but an offer document. An offer document which sets out the entire complete history of the company, which sets out what the company is into, what has the company done so far, what's the shareholding like, what is the legal tax implications that the company has had so far, what are the penalties, tax claims, if at all it has suffered so far, what are its projections, what does it think about the economy, how is it going to be helping the company, what are the projections of the company, all of that comes in. It doesn't talk about the investor rights obligations. This is predominantly a document to invite people to subscribe to your shares when it goes public.
So where is the shareholders agreement in this case?
That basically the shareholders agreement is there only till it goes into an IPO. After it's struck down, there is no shareholders agreement after that.
But the prospectus is a deemed shareholders agreement, isn't it? Because that's the offer which the company has made, and the company is now duty bound to abide by what is stated there, or it's not.
No. So DRHP is an offer document. Up until then, you may have had shareholders with whom you signed up the shareholders agreement. That is that. Now, after you go public, there's a trading which happens on the stock exchange. Every time there's a stock. So, okay, you and I both have shares in listed companies. For example, I have it in Reliance. I don't go end up signing a shareholders agreement every time. That doesn't happen. However, if you have a close-knit promoter-driven company where the promoter holding is by and large very significant, you may find an agreement being done on the side. But that is that. But when you and I are trading online, we don't really sign a shareholders agreement. That's not required. It's never done.
Wonderful. Understood. Super. That let's say an entrepreneur has signed the so-called shareholders agreement, and after that he finds or she finds that, oh my God, I should have signed something like that.
Yeah.
Is this something he or she can do to unravel the mistake done earlier, or it's cast in stone, nothing can be done?
I wish I could have had a better answer for this, but no. So look, I think communication is the key, to be honest. Therefore, one has to be very mindful of what kind of investors that you get on board. When I started off my practice as a transaction lawyer, the investors actually tend to be very picky and choosy about which startup that they want to invest in. But times have changed today. Promoters, founders are very picky and choosy about which investor they want to bring on board. They become more wiser and smarter, to be honest. So when you get investors of your choice, by and large, you know what you're signing off on. Now, if after signing off on a document, there's an afterthought, I think the only way to deal with it is one, that you have a conversation with the investor. And of course, ensure that you're out and about to raise funds from other third-party investors sooner, because then you're opening the document for discussion again, if that's possible. So whenever you get new investors on board, the shareholders agreement opens up for negotiation. Unless, of course, you've signed up something else in the document where, the existing investors have rights till they hold X percentage, That's a different thing. But otherwise, it becomes open for discussion each time that you do a round. But like I said, communication is a key. You'll have to communicate if you're not comfortable with something. And I think by and large, I have seen some investors being very open to, discussions and understanding what the promoter's concerns are.
When a equity investor, private equity investor, or angel investor, they invest early, and perhaps they could have some specific rights, specific restrictions, and then the company goes into public. It goes and become an IPO and becomes public. Does the original restrictions and rights, can that be protected or prevailed? Or then it becomes everyone is equal and you are a public shareholder, really doesn't matter?
No. some of the rights do go away. For example, you're as a preference shareholder. What happens is you have a liquidation preferential right, which means that whenever company realizes money and it is out there for distribution, the preference shareholder would get preference over an equity shareholder. It happens. That's there usually. All that gets knocked off. The fact that, if at all you want to transfer your shares and there is some kind of a restriction on your transfer, all that gets knocked off. It gets diluted to a larger extent. The concept of board composition, board observer, all of that gets trimmed down to that extent. So there's a large dilution that happens in terms of rights on at the time that you go in for an IPO, because the structure of the company is completely changing in that sense. It's going public. So it's a very different kind of framework that then gets applicable to you. So a private limited company framework will not work. And it may just be contrary or not in line with the regulation, actually.
Rohini, it was absolutely outstanding and brilliant. I think you have answered almost every question which was getting answered or asked while we were on the call on this program.
All right.
We still have perhaps a few minutes left. If anyone has a question, we'd be very happy to take it on. If anyone would like to get in to ask a question or two, Rohini is there to help. I guess you were so clear and your clarity was so fantastic. I think people here has understood exactly what is to be done, what are the do's and don'ts, what are the rights and obligations. People are, of course, giving you a thumbs up, Rohini. That's fantastic. I enjoyed every bit of it. I think there's so much of learning because it was extremely nice and informative. With sincere thanks on behalf of CII and for my sake, Rohini, it was absolutely brilliant and outstanding. Thank you so much, ladies and gentlemen. Happy Shareholders Agreement to all of you. Thank you. Bye-bye.
Thank you very much. Bye-bye.